part of very important historic records, not only for the Parliament, but for the country. So if members are so minded, I would ask that we defer these minutes to the next meeting. And I would say to the clerk, it is extremely important that the minutes are dispatched in advance of the meeting and that the draft be sent for corrections before they are disseminated. We cannot, it's one thing to correct to ensure that the thoughts are accurately captured, but when we have typos and sentence constructions and matters which this technology age shows it's part of your own editing left unedited, it makes it a little difficult. So if I have the concurrence of members of the committee, I will ask that items 5 and 6 be deferred. I'm seeking the concurrence to defer items 5 and 6. Thank you. Yes.
Madam Chair, on the minutes, I just wanted to say this, that I think I agree completely with your statement. I think we might have to exercise a little patience with the committee, because in my own outrage about the minutes, I have checked and recognized that the committee section has lost team members and they are literally a skeletal staff. So they are, I think, doing the best they can do. I think we have just 2 people managing all of the committees of Parliament right now. I know I have them under pressure in one committee. You have them under pressure in this one. And I think there are about 3 others that are currently meeting that have them under some pressure. So I don't know if we can, if the clerk can look at maybe some sort of AI tool that might assist them with the minutes, but I know it's difficult.
Your comments are noted, Member Golden. We sometimes underestimate the amount of work that has to be done with the skeletal staff. I do not, however, share the view that I have them under pressure. The work of the institution must be done, and must be done at the standard. All right. In light of my brief opening remarks, item 7 will also be deferred. Item 7 on the agenda, consideration of questions raised by the Leader of the Opposition at the meeting of January 5. Suffice it to say that separate and apart from the issue of the final court, it is very clear to me that the government and the opposition have very different policy approach on the matters of reform, even while we say that we are committed together to the goals being pursued. The administration of which I'm a part of has a very clear picture of where these reforms are to go in service of the people of Jamaica and improving the machinery of government. We consider that it is critically important when we put out information for the public to consume, that the information must be accurate. Accuracy matters and truth matters, because at the end of the day, the people will have to approve. And it requires responsible exercise of leadership in a context that is so distracted. I will say no more for now.
Madam Chair, I need some guidance because certain things have been going through my mind. With the absence or withdrawal of the opposition from this committee, and I really seek some guidance. The lower house moved a motion by which persons were appointed to the Joint Select Committee, in which the persons were named. And persons are not just, and the Senate did so also. And that's what that is, yes. Because for a person to be recommended and their names placed in a motion in either chamber, the person is inquired on first, are you prepared to sit on the Joint Select in relation to a particular bill? And when I look on the standing orders as to appointments that come from either chamber, it does not say that so many should come from the government and numbers from the opposition. It says that members can be appointed. So technically you can have a situation where all the members are from one side in an event. The motions were moved and there were no issues raised at the time of the motion being approved in either chamber. And we knew what we were coming here to review a bill. That's what the motion is about. And the bill is laid on the table of Parliament. And so persons would have an idea as to what the content of that bill is. Now, on the first day of this joint select, the opposition, as they have a right, because any comment can be made and recorded, they posed some questions, but they ultimately withdrew with a caveat that depending on whether answers are given or so forth, they may not participate. Now, in my mind, and I heard a comment made elsewhere by the leader of the opposition, who said he has not boycotted the committee, but they have put a pause. So I just did a quick research as to what boycott meant. And boycott meant withdrawal with protest. And from the statement that was given, I deemed their position to be one where they have withdrawn in a protest, because the CCJ issue was not contained in the bill. But we know what, because we have seen the report. Now, procedurally, is it a requirement that the chambers are informed? Because you were appointed to the joint select by way of a motion, at which point in time you did not raise an issue. Not saying that you didn't want to be a member of the joint select and some other person should be appointed. But when I came to the Senate on Friday of last week, there was nothing indicating that the senators who were appointed from the opposition have taken a position which is inconsistent with the motion. That put them at the Joint Select Committee to say, well, we have paused, withdrawn, we don't wish to sit on the Joint Select Committee to review the bill. I am wanting to get some clarification as to procedurally what should be the position. We are position as taken by the other members of the Joint Select Committee to absent themselves deliberately. It's not a situation that something arose on a particular day and you extend an apology. You have said with clarity that you're not participating in the process unless, and I find something inherently wrong with that, with the position that has been taken, and nothing further. No report to the lower house, certainly none to the chamber, the Senate, from which you are appointed with your consent, with the knowledge of what you were appointed to the Joint Select to do. So I really need some clarity on it. And having heard your comments in relation to the position where you said there was a post-cabinet press briefing, I wasn't able to observe that, in which you said you made comments which would have provided clarity or answers, or as the case may be. If the answers were given, are they satisfied? Because I noticed that there is still an absence. Or is it that they are waiting for an answer that will satisfy them, as against you just providing an answer which you believe should satisfy the situation, but there is still an absence here? The people of Jamaica are looking on us as a parliament and persons who should have great responsibility having regard to the nature of what the bill that is before us. One that has been spoken about, in particular about the republic, Jamaica moving towards a republic for decades, and we are now at this point. I believe that there is great confusion out there. I don't know if it is being created deliberately or otherwise, but you hear comments to say, well, we are all on board in moving to a republic, but then we get to this point, and then we are caught in this particular situation. But procedurally, I'm asking you, Madam Chair, what should be the procedure? Should there be a report that goes back to the lower house and to the Senate in respect to the position that has been taken? Are the persons prepared to honor what they committed to at the time when the motion was done? What is to happen? That is the questions that I posed to you.
Thank you, Member Sinclair. In effect, you have taken me right back to the agenda item. So just by way of correction, Standing Order 75-1 provides that every select committee shall be so constituted as to ensure, as far as is possible, that the balance of parties in the House is reflected in the committee. Right. So there is, in fact, a provision as a regulation of the Constitution, a procedural regulation that speaks to that matter. And that is why, depending on how many are represented on the government side and on the opposition side, a formula is usually worked out. The government has more than 2/3, and so you would pretty much have that balance reflected in the committee, even though we have made adjustments to provide for a greater say in matters that are referred to Joint Select Committees, a greater say by members of the opposition, and you would see the numbers going up. So that's the first thing. Providing answers to the questions raised by the opposition leader and a member of the committee raised the answer of the appropriate forum. I have said in a previous meeting and elsewhere that under other circumstances, the questions would have been posed or should have been posed in another way to the Prime Minister. They could have been done in the full House, a letter could have been sent, even if they were raised here, they could have been raised after the fact to bring attention to communication passed formally to the Prime Minister. But to the best of my knowledge, that has not been done. By way of amendments. And as I said this morning, the Prime Minister was written to by the leader of the opposition and a former Prime Minister urging him to move on with the reforms in respect of abolition of the monarchy, because there was no dispute on that matter. As a general approach, it is important that where consensus does not exist, you would work through consensus, but in an attempt to get on with it, if I'm to borrow that phrase. We took the policy decision to begin with the matters on which we have consensus, and also in keeping with the alteration mechanism in the Constitution, to focus on those matters that require the approval of the people to change. And if there were other matters on which there was consensus that could conveniently be included, we would include them. The terms of reference for the work of the advisory body, the terms were agreed, and it was made abundantly clear that the work would be approached in phases. So the quarrel that is breaking out probably relates to a feeling that somebody is going to emerge a winner and somebody is going to emerge a loser, instead of looking at it that these are national goals which should transcend the composition of the political parties in the parliament. I think the other matter is where we are in the life of the parliament and the focus on engaging the people for leadership of government in the next term. We can't wish away our context. We can't wish away the time frame in which we are working. The government that you and I are a part of are of the view that we must get on with the business of the nation. And that involves having the reform goals pursued earnestly. We have delivered on some of them in other areas. The economic reforms, the public sector wage bill reforms. Everybody in Jamaica knows that people are calling for new and improved ways of serving the people. They're calling for greater accountability, they're calling for greater order, they're calling for respect for law and order. And that is what we're doing. So the impression that is being given that the opposition does not know the approach of the government is really not true. And it's a quarrel about something else. It's a quarrel about who is leading, the approach being taken. But who leads a government is decided after an election. And you know, we have to respect that in the democracy. So even when national goals are agreed, how it is done, there may be competition on the how. So the tension, I believe, that is playing out is perhaps one which says only us can determine what and how it should be done. As a matter of fact, you know, in his statement, so the government says we are pursuing the constitutional reform work. And we are honoring the work done by previous reform groups. In his statement, the leader of the opposition gives the impression that only members of the advisory committee whom he had recommended were legitimate contributors to the process. That's the impression that he gave. It appears that his challenge with the process is located in a belief that only the People's National Party or himself as its leader can legitimize the participation of Jamaican citizens in the constitutional reform process. Go back and revisit what he said. It's no secret that his nominees on the advisory committee did not sign the report of the committee. And, you know, the signature page is set out in the document because these are historic records. They are set out there. None of the members, the 3 members nominated by the leader of the opposition, signed the report. This page of it, all right? And I think it's important to put on record that the other members of the committee who gave of their time, they are not to be viewed as making an illegitimate contribution. Jamaicans who were invited to serve, they were not legitimate because they were not selected by the People's National Party or its leaders, nor were they selected through a process that was dictated or led by the opposition. And, you know, I have to say, Member Sinclair, that I'm not really surprised by what has unfolded, even though I was hoping to see something better, especially when we're so near to an election and we want to demonstrate to the people that we have what it takes to be entrusted with the reins of leadership. So when I read through the statement of the leader of the opposition, a lot of what is said seemed to be not in keeping with what is verifiable. In fact, you know, those who are of the view that it was he who instructed the members of the committee not to sign, because we move from recommendations to implementation, seem to have a lot of support for that view when you collect the statements said all over the place. And I believe he did, in fact, say it, that he had given instructions for them not to sign the report. He said that the committee was reporting on matters that they did not agree to. Again, that is not true. Everything that made it into this report were matters on which we had agreement. Even on the day when the report was being signed, some matters were revised to take into account the views expressed. And it was done because the decision-making modality was one of consensus. And it was agreed that we would not put in the report anything that we did not have consensus on, because we wanted to move to implementation. Like I said, the terms were set out and the terms were agreed. So no one was taken by surprise about a phased approach. And no one should have been taken by surprise that the issue of the court was set for the next phase, because we were focusing on the deeply entrenched provisions which require a referendum to change, and any other matter on which there was consensus that could conveniently be achieved. So the claim that the government is trying to push a reform process and the recommendations down the throat, quoting, couldn't be farther from the truth. In fact, if anything is being pushed down the throats of Jamaicans, is accession to the appellate jurisdiction of the CCJ without a process that would enable Jamaicans to own their final court. Process is as important as outcome. So the impression being given is just really unfortunate, but beyond that, laced with untruths. All right? You know, before the report was even submitted to the cabinet, it was shared for the attention of the leader of the opposition. I'm going through this because of the issues raised, right? We even requested through the members the presence of the leader of the opposition before the committee. And I make the link between the work of the committee because we're implementing recommendations. Recommendations that were made long ago before any of us here was a member of the parliament. The cabinet, the wholeness cabinet, decided to honor the work of those who went before in the process. Same set of recommendations, just update them to see if assumptions held, what changes needed to be made. So when this committee was established to deliberate on what is now in the bill, it was done to ensure that we could, together across the aisles, agree on something, because the process in the Constitution requires that the bill be passed in the Parliament before it is sent to the people. So, we're either serious or we're not serious. We know that we can't accomplish it alone, but I want the people of Jamaica to know that the Wholeness Administration is serious about getting the work done in the best interest of the people. And we are demonstrating that we can be trusted to do so. And where we make mistakes, we will pick up and we will go, because you really only fail when you stop trying. And these are national goals that have been set to be pursued to further the goals of independent Jamaica. So I don't know if my long response has answered you. Mr. Sinclair.
The other concern which I had raised, which you did not address, is the fact that, to me, my assessment is, whether they want to put the term pause on their participation or boycott, or whether I don't see the difference. I want to know, having come to this joint select on a motion, what happens? What is the procedure if you have withdrawn, paused, boycotted, but you're not present. It's not like I am driving from Montego Bay, coming to Kingston to participate, and I encounter a puncture tire. And I call to say, please apologize for my absence today. What I have before me is a situation that they have taken themselves away from the process. Is it that the chambers are to be informed, and if there's a revision of those persons or new persons, so we can have a multitude of views and so forth, wherever they come from? Because the section that you read from the standing order said where possible.
Right. So
it can be that it is not possible. So I want to know what is the procedure.
Well, let's distinguish the constituting of the committee, which would reflect the balance. That's one thing. Once the committee is properly constituted, the next issue is to have a quorum to ensure that the decisions can properly be taken. And the same standing orders speak to what the quorum is, and that is to be agreed. So this is a quorate meeting and will be valid for the formalities of the meeting. However, as I said, that because the approval of the people is required, and we know it's not just any people, but those who are registered to vote for members of the House of Representatives. And we know that those who vote normally take their cue from the party they support. We would want to ensure that the leaders of the parties present in the parliament are part of the process. But we have no control over that. So it would be for the leader of the opposition to justify to the people of Jamaica that he has agreed to serve, and because he's not getting his way, he has taken the highway. Right? Because which final court is best for Jamaica is not which final court is best for Mr. Mark Golding and the People's National Party that he leads, or the Most Honorable Andrew Holness and the political party that he leads. We are in a representative democracy. We are put here by the people, of the people, and our decisions must be for the people. So, you know, the last point I will say is that the phased approach that we have embarked on was recently recognized as an intriguing possibility for constitutional reform process globally. And the experts who came to Jamaica and shared their views on their observations also shared that less than 10% of constitutional reform efforts succeed globally. And what they saw from where they were looking tells them that something right is taking place in Jamaica and how we're doing it. But as usual, we are sometimes our worst enemy. We have present, Member Sinclair, some members of the Kingston Technical High School. I gather 36 students and 3 teachers. I want to welcome you to the sitting of the House in Select Committee. So the Parliament sits in different ways as a full House, or it can sit in committees. And what is happening here is a joint select committee reviewing the most important bill, so say some of us, to be tabled in the Parliament since independence. And that is to have a Jamaican head of state instead of the hereditary British monarch, and to put the highest law of the land, the Constitution of Jamaica, in proper form. Many of you, if you are nearing the age of majority, I can't tell by looking, but you're high school students, you may get an opportunity to participate in the referendum to come. But if not, you are guaranteed a right to vote. And in voting, you get an opportunity to choose your leaders. It's a very important right, and I want you to pay attention to it. With every right comes responsibility, and I would like you to grow up to be responsible citizens. And I'm sure that your teachers are guiding you in the right path. And I say that because they have taken the decision to have you sit into the Parliament to see the work of the Parliament in progress, and that is a good decision. You are not allowed to interact with what is going on the floor, but you certainly can observe. If you have any questions, you can note the questions, and we'll find a way to answer them at an appropriate time through another medium. Right?
I appreciate the comments that you have made in response to my queries that I had raised. And in your comments to the students, you use a term which I used in a presentation, and I always use, that all Jamaicans, and in particular ourselves, who are sent here by the people, or for myself, not sent here by the people, as those from the lower house, but I know I bear a great responsibility, having been placed in the position at that we have to be responsible. And we have to get by certain things. Everything doesn't necessarily go in the way that we all expect it to, but we still have to be responsible and to ensure that we represent the people in the best way. And so I take away from the situation that we are in, and I may get cussed out for it, but so be it, that there are some persons who do not appreciate the responsibility that they have, Madam Chair, in respect to this process. And those are my views. You don't have to make any comment on it.
Well, you know, the interesting thing about a bill like this, it really allows us to exchange perspective on just the state of governance in the country. But just to say to the teachers and the student that at section 13, subsection 3M is set out a right guaranteed to Jamaicans, the right of every citizen of Jamaica who is qualified to be registered as an elector for elections to the House of Representatives to be so registered, and who is so registered to vote in free and fair elections. So bear that in mind. All right? By the way, there are so many last things to say. I will repeat as often as it needs to be repeated until Jamaicans understand that you don't get to your highest appellate court unless you have something to appeal against. And the courts that are of critical importance are your trial courts. And I'm not saying that to the exclusion of a final appeal court. I'm just saying that we have to look on the administration of justice in order to do justice to the people, those who use the courts to settle their disputes. So, Member Davis.
Thank you, Chair. I have listened to the question, well, the queries posed by Senator Sinclair, and I too wondered whether the Joint Select Committee, as presently composed, whether we would be affected in our deliberations by the absence. And I guess what you said just now clearly underscores that what is being done is in conformity with the standing orders, and as such, the work will continue.
Thank you, Member Davis. We are moving on. We are moving on. I am going to invite the team from the ministry to make a presentation. And I'll just share something that I shared this morning at the Cabinet press briefing. That government of Jamaica is arranged in ministries, departments, and agencies. And each ministry is assigned a portfolio of matters, subject matters, and accompanying legislation. Government is not a one-man show. It is not just the political directorate that makes up government, contrary to what some may think. Government is run by officials who have formal titles, formal roles, and specific functions. And the work that is done in the Parliament is supported by work done in the ministries by the cadre of professionals employed in government. And that is why there is always a technical team answering questions. We have to get back to understanding that work is divided up. All right? So we understand that there is a knowledge gap in the society on matters of governance, on matters that would have been included in the past in civics. And as we engaged with members of the public in this reform work, we realize that we have to help to educate. The bill is implementing a recommendation to retain the parliamentary cabinet system, which means that the head of state is not also the head of government. And the head of state is not going to be involved in the daily running of government. Because that is the context in which we are reforming the Constitution, it will be important to help to educate members of the public so that when we come to discuss why the recommendation is not for a directly elected president to replace the hereditary monarch, you will understand that in the context of our representative democracy. So I'm going to invite Mr. Harper, who from your team is presenting, PS, Ms. Mills, Sharika. All right, members, I invite your attention. I'm going to invite Sharika Mills to make the presentation.
Good afternoon. My name is Sharika Mills, and I'm the Constitutional Reform Officer at the Ministry of Legal and Constitutional Affairs. So I'm waiting a little for the presentation. Okay. All right. So as Minister mentioned, for context to the discussion on the Office of the President, as the main focus today will be on Clause 11 of the bill, the proposed sections 24 to 30, we will highlight some key differences between the presidential or executive system, or a system with an executive president, and the parliamentary system as outlined by the Constitutional Reform Committee in their report, and will provide some additional explanations to help you to understand the discussion. So at the proposed sections 24 to 30, you will see, if you follow the bill, that the subheading, the Governor General, has been deleted and replaced with the President. Further down in that same clause, the Office of the President is established. There's also the procedure for appointment of the President, which includes the nomination and confirmation process for appointment, tenure of the President, and immunity of the President. And so we'll get right into discussing the presidential system. All right. I'll proceed while the presentation catches up. So the presidential form of government is a system of governance in which the executive branch is separate from the legislative branch. In this system, the president normally serves as both the head of state, thank you, as well as the head of the executive government, and this person is not usually a member of the legislature. You will see this outlined at paragraph 5.1.2 of the Constitutional Reform Committee's report. The presidential system of government originated in the United States of America and its Constitution of 1787. In this system, executive power is vested in the office of president, and daily administration of the federal government is carried out by the president's appointed cabinet. The U.S. Constitution gives the president a pocket veto, which means that the president has an indirect veto of a bill by retaining an unsigned bill until it's too late for the Congress to deal with it. And you can see how this withholding of assent can cause gridlocks and legislative stalemates. So the president can withhold assent, but can only do so for 10 days, after which the bill is considered passed, limiting the president's power to unilaterally obstruct legislation. The president can also return bills to Congress with objections for their consideration, which can hinder but will not prevent progress in implementation of the legislation once you still have those 10 days to pass for the president to assent to the bill, because Congress has the power to override this decision. And this is a common feature in presidential systems. As is also common in presidential systems, the U.S. Constitution provides that the president has the power to appoint federal judges and various other officers through commissions. So although the president is indirectly elected by the people, the system also preserves some level of public participation in the election of the president, and that's a hallmark of presidentialism. This type of election is intended to underscore the president's role as a unifying figure, and this is a perceived strength of presidential systems, that democratic legitimacy of a president who is elected through some mechanism that allows for public participation. And the importance of this is that the president is seen as a figure who represents the values of the state and personifies the country's political stature beyond the partisan fray. But in reality, in this system, it heavily depends on the individual who sits in the office of president. In systems constructed like that of the United States, the president has, in fact, been a socially divisive figure, even though the people play a role in the election. The primary strength of presidential systems lies in the clear separation of roles and powers which exist between the executive and the legislature. However, this separation is not as clear as it may be perceived, depending on the constitutional arrangements of the particular country. And so, for example, in the United States, the president can issue executive orders which give instructions to executive authorities and often clarify or further existing laws. Slow down.
Madam Chair, I'm so sorry to interrupt. It's an excellent presentation so far. Can I just ask you to slow down a little bit?
Yes.
Thank you.
I will. I'm sorry about that.
Member Golden, I'm sure Mr. Harper will be smiling to say at least he's not the only one who was asked to slow down. Ms. Mills?
I will.
An excellent presentation to be delivered at a slower pace. right? While we're building out constitutional law expertise in the ministry, not everyone is building it out, and the public listening on too would like to pay close attention.
Yes.
And I think Member Goldin has arrogated onto herself a particular role to remind all of us that this process is not just about us in here. And so we must always remember the public looking on.
Yes. So, depending on the presidential appointments, as we discussed before, the president can make a range of appointments. And the nature of these orders, significant executive overreach can occur, resulting in presidential decisions that are made in the absence of effective accountability measures. And lastly, the presidential system is perceived to provide an opportunity for additional checks and balances on the legislature in the form of the presidential veto. This, however, is a double-edged sword. While it can provide a check for the legislature when excessive measures are being taken or draw attention to issues of national concern, as we discussed before, it can also cause gridlocks and legislative stalemates. And so now I will move to discussing the parliamentary cabinet system, that we understand the features of the presidential system. And I will start here by giving this definition of the Westminster model. And so we acknowledge that the parliamentary cabinet system is a broader system, and that the Westminster model is a type of system under, is a model under this system. But the Westminster model is the originator of the model that exists in the Caribbean. And so we thought this definition was still suitable. So it's a constitutional system in which the head of state is not the effective head of government, in which the effective head of government is a prime minister presiding over a cabinet composed of ministers, over whose appointments and removal he or she has at least a substantial measure of control, in which the effective executive branch of government is parliamentary, in as much as ministers must be members of the legislature, and in which ministers are collectively and individually responsible to a freely elected and representative legislature. And so, quite simply,
I'd like you to pause there so it can sink in, because I don't think that many people understand it. Right?
all right.
In which the effective executive branch of government is parliamentary, in as much as ministers must be members of the legislature, and in which ministers are collectively and individually responsible to a freely elected and representative legislature. Because we're going back to basics.
But we'll break down also in simpler terms and say that a parliamentary cabinet system of government, is a system of governance in which the executive branch derives its legitimacy from and is accountable to the legislature or the parliament. And in these systems, the roles and functions of the head of state, who would be the president, and the head of government, who would be the prime minister, are separate. So the head of state primarily performs limited functions, most of which are carried out on the advice of the cabinet, the prime minister, or the leader of the opposition. A non-executive president, which is most common in parliamentary republics, rarely acts on their own discretion. On the other hand, the head of government, the prime minister, is responsible for administering government, making policy decisions, appointing ministers, and leading the legislature. As I stated before, most parliamentary republics have a non-executive president as head of state. This president serves as the symbolic leader of the state, performing primarily ceremonial and civic roles without exercising executive or policy-making power. The key strength of a non-executive presidency in a parliamentary republic is its ability to act as a stabilizing force. The president is not involved in day-to-day governance. They can serve as an impartial mediator in times of national or political crisis. The president acts in circumstances where representation from the state and not the government as such is necessary. And this division allows for a symbolic separation between the enduring state institutions as embodied by the president from the more temporary nature of the government. Parliamentary republics are therefore able to project continuity and stability even as governments change because presidents remain more static and facilitate non-partisan state participation through the office of president. So
Sharika, can you repeat that part? Because context matters, and Jamaica has gone through and is still going through economic reforms. We cannot tinker with the stability of the nation to be set back. And I want Jamaicans to understand that the matters being implemented are considered in the wider context of what is best for Jamaica. And also the issues raised by members of the public, we have had to sift through to get a sense of what really are they asking for. Now, during the consultation with members of the public, we had almost the same set of voices in every space asking for the executive presidential system. And when those voices were medialized, it gave the wrong impression that everywhere people were asking for the executive presidential system. It's just that the same set of people were present practically at every place. And then we also realized that the call for the executive presidential system was a proxy call for other issues in government around accountability and responsible government.
Yep. So in this system, the head of government, who is the prime minister, is typically a member of the parliament and is chosen on the basis of leadership or support of the party, which gains a majority in the parliamentary elections. And so the president, as head of state and part of the executive branch, derives legitimacy from and would be accountable to the people through the parliament. The process outlined in the bill for appointment and removal of the president lies in the parliament for this very reason. It is a demonstration of the source of accountability, which is a parliament which derives its own legitimacy from the people in a system of representative democracy.
To pause there because I also want to make a connection between some of the other steps taken but which remain incomplete. So Prime Minister Holness indicated that we would be engaging members of the public to look at the role of the parliamentarian and a job description. And a committee was established and some meetings were held, and that work is still work in progress. But I want everyone to understand that there is a link between that and what we understand the strength of our system of governance to be. Unfortunately, the economic decline that we have experienced for decades have just mashed down and popped down our system. And we really are picking up the pieces and reestablishing the foundation of the nation in the interest of the people. And it's going to take some time for everyone to understand the link and understand what a parliament is supposed to be, and to also understand that the freely, periodically elected legislature is the foundation of the democracy. And we're not going back to the public square. We have a representative government where people get to choose, and they have a right that is guaranteed in the Constitution to vote. And you know, we are just making the link. I don't expect that the presentation by itself will allow for the kind of understanding that needs to happen, but the ministry, through the subject matter of legal education, is working in the small and not so small spaces to bring awareness to the people on these matters. And I had the privilege of seeing the team at work in St. James, and I couldn't be proud of them. The schools were gathered, the high schools from St. James and Hanover were present, and man, you know, so when the impression is being given in some place that nothing is happening, quite the contrary. It's just that in this age where so many things are distracting you, or if I were to put it otherwise, there's so many things trying to attract your attention, a lot is happening. But I'm asking everyone to spend some time to get to understand what the parliamentary system is about. Because everywhere we turned, people have been asking for greater accountability, and the responsibility is ours to help you to understand the issues, to break down the system and tell you what it should be, because we have to work to make it work in the interest of the people.
Well, that link is exactly where I was headed, to mention that in representative democracies, citizens vote for government representatives to handle legislation and otherwise govern on their behalf. And so the legitimate acts of the representatives can be said to be that of the people themselves, who have consented to their leadership in free and fair elections. Representation is best characterized as a mechanism that organizes the political directorate at the level of the legislature so that the will of the people can be determined. The citizenry obtains political equality through the distribution of voting power based on constituencies rather than corporate interest or cultural identity. And it's this equal distribution that gives the system its legitimacy and its authoritative power. And so in essence, to put everything simply, the legislators or the decision makers are legitimated or authorized to enact public policies and to carry out legitimate acts on behalf of citizens and are subject to public control at free and fair elections. We have mentioned many times that in a parliamentary cabinet system, the executive is accountable to the parliament for their actions, and so we want to take you through some accountability mechanisms so you can see in practical terms what that means. And Mr. Philip Cross, our Senior Constitutional Reform Officer at the Ministry, will be taking over that part of the presentation. Thank you.
Thank you, Sharika. Philip?
Thank you. Thank you, Ms. Mills. Good afternoon. So I'm just going to walk through, following up from what Ms. Mills would have just presented on, to talk about some of the accountability mechanisms that would be present under a parliamentary cabinet system, particularly under the Jamaican context, under the Jamaican Constitution. And I'll do that by reference to the existing constitutional provisions, given that under the bill that's now being discussed, there is no proposal to adjust in any significant way the existing safeguards and accountability mechanisms. So I'll start off with the Constitution itself as the foundation and its standing orders, which are the regulations that govern how the Parliament conducts its affairs. I'll also touch on several other accountability mechanisms that recognize the parliamentary cabinet system, and there are certain common features that you will see as I go on that recognize the way that it is structured. So returning to this, the quotation that was given earlier, we will recall that each of these features is actually present in the Jamaican Constitution. We see that the head of state is not the effective head of government, so that would be the Governor General, or pursuant to the proposed amendment, the President. The effective head of government is a Prime Minister presiding over a cabinet composed of ministers over whose appointment and removal he or she has at least substantial measure of control. So in this context, well, we'll see in the next slide, but we have that system as well. The effective executive branch of government is parliamentary, in as much as ministers must be members of the legislature. So we will also see that to even be a minister or the prime minister, you must be a member of either one of the houses. And ultimately, based on this section of the presentation, ministers are collectively and individually responsible to a freely elected and representative legislature.
Just to indicate that a prime minister can only be drawn from the elected house.
Yes.
Not the appointed house.
Yes.
So we have appointed legislators, Senators Sinclair and Golden Campbell. Myself and Member Dwayne Smith are from the elected house. So those who are looking on under our system, the other person, minister, who must also come from the House of Representatives is the Minister of Finance.
Thank you. So returning to the accountability mechanisms, we see that this concept that we've been discussing of the parliamentary cabinet system, in which the cabinet is accountable to the parliament, is enshrined in our constitution at section 69.2, which you can see there, and it speaks specifically to the same expression in the definition mentioned earlier, that the government of Jamaica, that the cabinet shall be collectively responsible to the parliament. And then, stemming from that, the Governor-General shall appoint as Prime Minister the member of the House of Representatives. So as the Minister said, it isn't just either house, but it must be, the Prime Minister must be a member of the House of Representatives to be Prime Minister. But not only that, he must be able to best command the confidence of a majority of the members of that House. So what this means is, in an indirect way, the Prime Minister is accountable to his cabinet in that he has to be able to command the confidence of that cabinet, and that cabinet is in turn accountable to the Parliament, which is the legislature. Sorry. Yeah, and then under Section 71, the Prime Minister is also accountable in other ways because he is required to be a member of Parliament in the House of Representatives. If he ceases to be an MP for whatever reason, or if a minister ceases to be an MP or a senator, both of them, either of them, respectively, will lose their position as Prime Minister or a minister. Because the Prime Minister must be a member of the House of Representatives and a minister must be either an MP or a senator. And if there's a successful resolution of the House to revoke the Prime Minister's appointment, then that can also result in the Prime Minister losing his position. And depending on his response to that resolution, it can result in an election. So the Constitution has a provision which speaks to whether what the Prime Minister does within 3 days. If he chooses to resign, or if he chooses to have the Governor-General dissolve Parliament instead, which would result in a new election. And then the minister, who is appointed by the Governor-General on the direction of the Prime Minister, can be removed essentially at will. Once the Prime Minister gives the directive to the Governor-General to remove a minister, then the Governor-General will do so. And then, again, the cabinet is accountable because a no confidence vote may be sought under Section 64(5). And if an absolute majority of either house is obtained, then the parliament is also dissolved. And we have seen a few of these examples in the media in other countries where, for whatever reason, the Prime Minister loses the confidence of his cabinet and or the parliament as a whole, and a no confidence vote is put forward, and as a result, he is forced to vacate his position.
Just pause there. Let me just say to members here and to those who are watching, this presentation is helping to contextualize the provisions that we're going to be reviewing next in the bill. When we interacted with members of the public, it was clear that they did not understand the system of accountability. And so their call for a directly elected president was a proxy call. They felt that if they directly elect a president, then that meant there would be a greater system of accountability without understanding the very intricate system of accountability that the Constitution has. And what this reform is seeking to do, again, is to refocus and redirect government to make sure that what has worked well and has created and contributed to stability, that we don't tinker with them, because sometimes systems are very good, it's just the system drivers that create the problem. So for those of you who are watching online, I am asking you to pay close attention to this.
So moving to the standing orders, another issue that is topical is the issue of absences from Parliament. Now, the Constitution prescribes that the standing order, the houses may regulate their proceedings, and they do so through the standing orders. And there's a set of standing orders for the House of Representatives, which is the elected house, and there's a set of standing orders for the Senate. And in each case, there is specific provision for what would happen if there is an excess of absence from Parliament without approved leave. And in the case of the House of Representatives, that amounts to 6 consecutive sittings within 21 days. And in the Senate, it is 5 consecutive sittings within 40 days. However, there is a time period after that extended absence where the parliamentarian can put forward a justification for their absence. And if it is to the satisfaction of the Speaker or the Senate President, then they may be excused for that period. But just to say that there is in fact an existing accountability mechanism long established with respect to this issue.
Just to say that currently the standing orders provide that the House shall meet on Tuesdays, Wednesdays, and Thursdays. But generally we meet on Tuesdays. And I'm pointing these things out, because what we are hoping to do with these reforms, ladies and gentlemen, is to bring back the work of government in a regular way. Members of Parliament have been asked to perform so many other functions assigned to other parts of government. And when the spotlight is focused on the members of Parliament, those other parts of government seem to be in the shadow. And that's why it's also important that the public understand that the ministry is not a one-man show, that there's a team of competent professionals who help with the work, and they must understand that the work is divided up. Because when we, as members of Parliament, make representation on issues, we still have to wait for the relevant part of government to do the work. I use this as an example. Someone goes to the tax office and they have a bad experience. And immediately they want the Prime Minister to address it. No, the Prime Minister is not the person who is discharging the functions of the tax office at the point of interaction with member of the public. And the quality of that interaction or the quality of the service may depend on the politeness of the official or any of many matters. And we have just moved away from spotting and correcting the fault where it occurs and casting aspersion over a whole system that is otherwise good and can function well. So those of you who are watching understand that it's not just a presentation for presentation's sake, because we anticipate that some may still come and say they want a directly elected president because they believe that by so providing they will get greater accountability when they do not know the accountability mechanism in the Constitution and what we are preserving with a view to strengthening.
I'll be quick at this. But we're speaking about accountability and absences from Parliament. But we had a little quiet discussion, myself and my colleague, Senator Golden Campbell, that it is noted that there is nothing that speaks to absences from joint select committees or committees in general. And if we're looking at accountability, then I think we would have to look at accountability right across Parliament, including those in the committees, Madam Chair.
Well, thank you for that, Member Sinclair, because it may go right back to you as the Deputy Presiding Officer in the Senate, and I will certainly take it on, because part of this process is to help us to identify gaps. Regulations of the Constitution are to be viewed with the level of significance that should come from them. So that's a gap. That's a gap. And Parliament work effectively through committees, right? Duly noted. I entreat you in your role as a Deputy President of the Senate to have conversation with your President, and we certainly would welcome any proposal, notwithstanding that there is a formal process set out for amending the standing orders that we could consider, since this work is a direct response to the cries of the people for greater accountability. And we're saying to the Jamaican people, we are prepared to get it done.
From the point of view of the Senate, we are presently undergoing and close to concluding our standing orders committee, where we have reviewed. We are in the review stage of the standing orders, and myself and Senator Golden Campbell. sit on that committee.
So the only thing I would say, if that matter was not considered, please include it. Wonderful.
So continuing with the provisions under the standing orders, Minister would have mentioned earlier how a Prime Minister would appoint several ministers, each of which would have a portfolio, and they are responsible for that portfolio, and they brief that Prime Minister on matters under their management. The standing orders recognizes this concept, and one of the key functions of, or one of the key mechanisms, of accountability in a parliamentary cabinet system is that of transparency, which is manifest through the questioning system. And both sets of standing orders speak to specific reserved, prioritized question time. So the standing orders of the House of Representatives has both a reserved period for questions to the Prime Minister, which is the second sitting in each month, and for ministers, it's the first sitting day during any week. And that is the case in both the standing orders for the House of Representatives as well as the standing orders for the Senate.
Before you go on, Philip, just to say to members of the public, this is a matter that is more honored in breach than observance over many parliaments. But certainly people need to be reminded, including parliamentarians, of what it was designed to do. Because again, what we have been doing in the Wholeness Administration is to look at the systemic weaknesses. Or if it's not the system that it's weak, but it is how the system is administered, then we are identifying those points of weaknesses in order to ensure that the people can be better served.
And so stemming from the questioning system, a minister has to account for the performance and the activities under that minister's portfolio, the ministries and departments and agencies under their portfolio, and give an account. And from that, the Parliament can then hold that minister to account for their performance, and doing so in the parliamentary setting also then highlights these issues in the public domain, which then allows the electorate, the persons who vote for their representatives, to decide whether they're satisfied with with their governance or not. Also, the standing orders speak to select committees, so this is a joint select committee, but it speaks to select committees which may inquire even further into certain issues, and that would allow them to be ventilated further, allowing transparency to serve accountability in the Parliament.
And this is an example of a select committee, joint select committee, meaning joint by way of both houses represented on the committee.
Now, another entity that had been created, I think it was back in 2002 or 3, was the Office of the Political Ombudsman. The Political Ombudsman is accountable to Parliament, and their mandate is to investigate the actions of a party or its members, essentially to see if their behavior is in line with a good, a good political system. So the specific items that they are responsible for would be whether a particular action that they investigate is a breach of an agreement, a code, or an arrangement between the political parties, or if the action prejudices good relations between the supporters. Now, what's interesting about this office is the fact that it speaks to the breach of an agreement, a code, or an arrangement. And the reality is that a lot of the rules and the documents that speak to the, the interactions of parliamentarians may come from a code or other type of document that one might say is not legislation. But even though that's the case, there is still a mechanism in law for a breach of such a code to be investigated, reported on, and then tabled in the Parliament. And again, that serves greater accountability and encourages better interactions between political parties and their supporters. It should be noted as well that the Electoral Commission of Jamaica is now the political ombudsman following the 2024 amendment, and subject to the proposed provisions of the bill, the Electoral Commission, and therefore the political ombudsman, would be entrenched in the Constitution, meaning that it would require a 2/3 majority of all of the members of both houses to make amendments to that office. And then we have the Auditor General. So we're actually going back to the Constitution now, because the Office of the Auditor General is established in the Constitution under Section 120. And the Auditor General, she's responsible for doing annual auditing of all of the departments and offices of government, which includes the Office of the Cabinet. So going back to the main topic of the responsibility of Cabinet to Parliament and the responsibility of the Prime Minister to the Cabinet, it should be emphasized that the Auditor General is responsible on an annual basis of doing these audits. And the reports of the Auditor General are tabled are to be laid, submitted to the Speaker, who will then cause them to be laid in the House of Representatives, once again engaging that mechanism of accountability. And then lastly, we have the Integrity Commission, which needs little introduction, and I know that it is also currently under discussion in terms of, I think, a separate joint select committee. But it is also a commission of Parliament, and in that context, it is accountable to Parliament, it reports to Parliament, but it has a mandate for the investigation, prosecution, and prevention of corruption. That's a very brief summary of the list of its mandatory functions, but essentially that's what it does: investigate, prosecute, and take steps to prevent corruption.
Just hold on, Philip. Yes.
Chair, I'm sorry. Can I ask, like on the last occasion, as you're going through, can you just indicate the clause in the bill that you're referencing? Because it's a little easier to, I'm following my bill and I'm following what you're saying.
Well, just to say that this really is just setting the context for the discussion that is to come on the Office of President and the model that we have chosen, and to help the people understand that this choice does not mean that there isn't a system for accountability within our constitutional arrangement.
So Chair,
Yes.
so what I was really trying to just make sure is that the explanation and the context is not exactly necessarily saying that there's an amendment proposed to the Auditor General section.
No,
Okay,
but what Jamaicans will understand is that because we're putting the Constitution in proper form, these amendments, when made and approved, will merge with the existing provisions here for the reformed Constitution until we get to the other phases and we're able to examine all of the provisions. But right now we are keeping what has worked, and in the Constitution is an intricate system of accountability. And those remain. And the provisions that we're changing will relate to that wider system, or what is called the constitutional scheme.
Yes. You may recall, Chair, that I have a particular interest in that section, having had some interventions last year on the accountability question in the Auditor General provisions, a position that I have not heard countered in the public domain. So I have a particular interest, we proceed.
You know, Senator Golden, but just to say again for those who are listening, the clause 28 of the bill, which sets out the insertion of a new part to Chapter 5 in relation to the Electoral Commission, and the Electoral Commission now discharging the functions of the political ombudsman. So it's all related. But the real point is that our Constitution is actually a well thought out scheme of interrelated parts. And we have to be careful how we tinker with one, because it has implication for another. And I want to assure members of the public that we spent a lot of time looking at that, and we were ably assisted by experts, including our own Dr. Lloyd Barnett, whose work is well respected in the field. And it will also explain why everything is not happening all at once.
Very well, Chair. Thank you.
Thank you. So I guess just to clarify then, what I'm presenting is essentially the Constitution as is, because with the context of what currently obtains in terms of our constitutional provisions and accountability mechanisms, the idea was that context will help to better aid persons in examining what's being proposed. And I'm referring mainly to the existing constitutional provisions because they're not proposed to be amended in a substantial way other than for some name changing and that sort of thing. With respect to the Electoral Commission, as the Minister said, there are some amendments there purely because it was thought ideal to try to enshrine the ECJ, given its functions, in the Constitution. So that one is one of the areas where there is an amendment. But for the most part, everything I'm mentioning is the existing law and the provisions. So with respect to the Integrity Commission, as I had mentioned, it's mandated to investigate, prosecute, and prevent corruption, which is a major concern, obviously. And it has special provisions relating to parliamentarians, the opposition leader, and the Prime Minister, which are well known. I don't think I need to go into it. And there are broad powers of investigation. Now, when the Director of Investigations finishes a report, that report is tabled through the Executive Director, and the Commission, and submitted to Parliament for tabling. And what is interesting about this legislation, separate and apart from the others which have a similar function, is that the Integrity Commission legislation includes in it specifically the powers of prosecution. And so where it is that an investigation report reveals something which the Director of Investigations believes constitutes a criminal offense, that is referred to the Director of Corruption Prosecutions for consideration, and the Director of Corruption Prosecutions will examine it with the same level of scrutiny and with the same standards as would the Director of Public Prosecutions. And it should also be pointed out that the Director of Public Prosecutions always retains supremacy when it comes to the prosecution or non-prosecution of any offense. So what's interesting about this legislation is beyond simply the transparency mechanism of putting forward a report which is tabled, discussed, and aired, there is also a mechanism directly where the need arises for prosecutions to take place as well. And so with that, thank you.
All right. Any question? All right. Thank you, team. Well done. Thank you. I hope that the presentation will assist those who are paying close attention to the work that we are doing. This is the extent of today's work. I'm going to ask that the presentations be placed online for those who wish to access them at the Road to Republic, and we will also share it with the Parliament, that it can be placed online on our own ministry website. Is there any other business members wish to address? I was informed earlier by the committee coordinator that in the interest of accuracy, the staff is not as menial as was suggested, but the work is still heavy for the team. All right, we had proposed next Wednesday, well, tomorrow, for the next meeting in the event that we were able to go ahead, but tomorrow is not convenient for the chair and some other members of the committee, and we wouldn't want to not be quorate. Next week, Wednesday, I will be working with an international delegation of parliamentarians backed by the World Bank and the IMF on a field trip to Jamaica. So next Wednesday is not going to be, so we will set it for Thursday the 6th. All right? Sorry? No, well, that Wednesday, but we have the rest of the dates set, 12, 19, 20, 28, 27, and we must. Well, we'll take into account anything else that is happening in the Parliament, and I think prorogation for a new term. Next date would be the 6th. Thursday the 6th, yes. 10. The 6th, Thursday the 6th of February. The 5th, yes, but I just indicated that, yes. Other matters. Yeah. And then it would be the 19th, 20th, 26th, and 27th, all things being equal. Yes. 20th, 26th, and 27th. That would take us up to so the week of the 19th, the sessions of the 19th and 20th, we will start considering the submissions from the public.
I haven't seen the advert or...
Well, we have submissions that have been coming in, you know. How many submissions, Madam Clerk, have already come in? 4 submissions have so far come in. We will determine, depending on the issues, because some submissions are going to be raising the same issues. Yeah. And we will, in order for efficiency, because some matters, subject matters were raised, we're reminding everyone that it's a bill that you are going to be submitting on, the bill, not just a subject matter at large. Already, okay, but I can't hold up your file. The committee clerk is showing me the advertisements, please. I know already yes. They're asking for extension of time. We will do our best to facilitate those who decide to submit, but I urge everyone to put your submissions together. It's not about shutting out anyone, but it's also about the timely disposal of matters in the Parliament. And it's not a rush, because we have been talking and talking about constitutional reform. The bill was tabled and a whole month was given. It was immediately made available.
I'm so glad you made those remarks, because I heard a critique of the messaging, communications. I think it was on Monday that I took on to myself, even without giving you a heads up on it, to correct. And I actually had spoken to the Parliament to ask them what were the actual dates, because I know the committee had indicated that the message should go out. But there are just 2 things I want to add to what you said, Madam Chair. One is messages I know went out, I think it was the 17th of January, and admittedly the time is a little short, but as Madam Chair has said, we will do our best to accommodate submissions. But also, I did hear it remarked in the public radio that a particular organization had not gotten a special invitation or a specific invitation. And to be clear, the Parliament is not in a position to send specific invitations to every single entity. But the general call is the same call that the Parliament may send to a specific entity. And so once the general call is out there, any interested entity is able to respond to that. They don't need to wait for a specific letter from the Parliament. We as a committee had suggested some names, and oftentimes we will do that when there are particular bodies that we think their contribution will be helpful. But for the public to know that the call is out for submissions, and any entity, any individual is at liberty to send a submission on the topic, that is the bill, as the chair has said, into the clerk of the Houses of the Parliament.
The only thing I would add, Member Golding Campbell, is to tell all Jamaicans that you are all special. And if by chance you were not singled out, it is no indication of how special you are. So if you wish to submit on the bill, please do so. We will consider your submission. All right? So the date and time of the next meeting is February 6, 2024 at 10 a.m. And my closing remarks is just a reiteration that all are special. We invite you to pay close attention. Will someone move for the adjournment of the meeting at 3:46? Very well. On a motion by Member Smith, seconded by Member Golding Campbell. Thank you to the team. Well done. Please ensure that the minutes are out early enough.